What's up, everybody? I'm Clint Powell once again here with Eric Buchanan and Associates. And let's just jump straight into it. We're going to bring Eric up. We got a deep dive today around the topic we normally discuss is ERISA. But first, let's say hi to Eric. What's up, Eric Buchanan?
Hey Clint, how are you?
I'm good. Can you hear me okay?
I can hear you okay now, but you are on about a full second delay
Well, you know what that means, don't you?
that we're being monitored.
It's Big Brother. No, there's just an internet thing. It'll catch up with us in a minute. Are you okay to move on?
Yeah, you're doing it now. You're doing good. Yeah, for the
Okay.
first, yeah, we're good.
Yeah, it moved it. I think it caught up with us. I got a little internet connector thing over here. It looks like we're pretty good. All right, so we've done several of these deep dives around um, ERISA, what it means. People can, if they're on the website, they can go back and listen to those past conversations. Today, I'm going to frame it really clumsily, and then you can do what you normally do and untangle Clint's words. But it's basically the process once you've been denied, the claim has been denied, you start going back and forth. We're going to talk about a couple things. One, why it's important to get an attorney like you and your team involved early on in the process, because once it gets to the judge, and I used the word trial before we came on, and you're like, I guess you can call it a trial, but really the judge is going to be looking at documents, and the documents he's going to be looking at have been kind of time stamped. Like at a certain point, that's all you're going to be able to get in front of that judge, right? Is
Yeah,
that a
that's
setup?
yeah, that's kind of basically it. The big question I get from clients all the time is, well, why won't I have a good case in court? My doctor's going to come in and say how disabled I am, and I have to say, it doesn't work that way, unfortunately. In most courts, the judge is only going to look at the documents that the insurance company had, what you submitted, what your attorney submitted, what the insurance company gathered. You mean I don't get a trial? Not if ERISA applies. You mean my doctor didn't get to come testify? Not if ERISA applies. You mean I
Mhm.
don't get to come in and testify? Not if ERISA applies. And so that why is that true? And what can we do to fight against that to give people the best chance? That's what I'm hoping we're going to get into today.
Well, because again, I know we've said it a lot of times on these deep dives, and it's okay to say it now because this may be folks' first time listening to this. It's important to know that because you just said it. If we get to the point where it's getting ready to get in front of the judge, and I have not had an attorney that's well versed in this and says, "Let's get all of this stuff in," the clock is ticking. If I get to that point, you're a really, really, really good attorney, Eric, but you can't change law and you can't get exceptions to the rules, right?
Yeah, that's right. Now, some circuits around the country have slightly different rules, but in most circuits, which means in most of the United States, the rules are pretty strict, and the court is not going to look at documents that you did not submit to the insurance company, or that your attorney did not submit, or that the insurance company put in there. And so, part one of this to understand is the insurance companies know this game. And so the
Right.
insurance companies know that they're putting stuff in the file so they'll look good in front of the judge. And then they ask you leading questions, and they send people out to surveil you, and then they gather a little bit of your records, but they don't gather the good stuff. And then when you get denied at the end of the appeal process in front of the insurance company, and you usually only get one appeal, rarely do you get two, usually it's just one. You get in front of you get in front of the judge, and the judge says, I can't look at anything else. This is all I'm allowed to look at is what the insurance company had. And if you submitted it to them, I'll look at it. But if you didn't submit it to them, I can't look at it.
Okay, so this is where I'm going to ask the question. You may say what famous with me. Okay, Clint, I'll answer that. But first, we got to set it up. Well, my question is, why is that? What? How did that become the law of the land? And is that good? Is it bad? Is there ever a chance that'll change, or do you think it shouldn't change? How did that become the case?
So it is actually slowly changing because some circuits under some circumstances are reevaluating the rules. So part of understanding this is that the if you're not familiar with the court system in the United States, ERISA cases are almost always litigated in federal court. And federal courts are located in big cities in the United States. Tennessee, where I'm located, has three grand divisions: Eastern District, Middle District, and Western District. And say, for example, in the Eastern District, there's a courthouse in Chattanooga, one in Knoxville, and one in Greenville. That's all part of the Eastern District. We lose a case here, or if the insurance company loses and they want to appeal, they appeal to the Sixth Circuit, which is in Cincinnati. And so the Sixth Circuit covers uh, Tennessee, Kentucky, Ohio, and Michigan. There's other circuits that the First Circuit covers like Maine through Massachusetts. The Second Circuit covers New York. The Third Circuit has Pennsylvania in it. The Ninth Circuit has California, Montana, Hawaii, Alaska, a whole bunch of people in the Ninth Circuit. So each circuit can have their own set of rules until the next appeal above that, you go to the Supreme Court. Well, if the Supreme Court hasn't addressed something, hasn't made a rule on something, and there's not a clear rule under the law, then each circuit ends up making their own rules. And that's essentially what has happened here with this ERISA rule, that the court's only going to look at a closed record. So let me kind of be real nerdy and clear about this. There is nothing in the ERISA statute itself, the original law passed by Congress back in 1974, that says if you lose your ERISA case and you take it to court, if the insurance company won't pay you and you have to sue them, there's nothing in the law that says all the judge gets to look at is the closed record, the documents the insurance company had. It doesn't say that in the statute. The federal rules of civil procedure are those rules the courts put together and that end up essentially getting passed by Congress or approved by Congress, so that those are the official rules of federal courts. The federal rules of civil procedure also do not address ERISA cases. And so there's no rule in the federal rules of civil procedure that says that you are limited to just the record, the documents that were submitted
Hmm.
to the insurance company. There's also nothing in any of the federal statutes that govern how federal courts work that limits it to a record.
I hope there's a but coming up soon because right now I don't know why you people are living this way.
On top of all that, the Supreme Court has never issued a decision limiting ERISA cases to a review on the record. However, now we get into the big but.
There we go.
Virtually every circuit in the United States has made it a rule that when you get denied by the insurance company and you appeal and you submit everything on your appeal to the insurance company, and the insurance company says this is the final denial under this policy, under this plan, we don't have to look any more information, and your next step is to take it to federal court. Almost every circuit really has a one version of this rule or another that says all we are going to look at is the information that was submitted to the insurance company. Now I'll put a big but kind of giant asterisk here. The Seventh Circuit, which covers Wisconsin, Illinois, and Indiana, they have a rule that in some cases under a different standard of review that you might be allowed to have people come in and testify in court, but it's only if you have a certain type of review called a de novo review. Other circuits, like the Sixth Circuit where we are, that covers everybody in Michigan, everybody in Ohio, everybody in Kentucky, everybody in Tennessee, that if your case goes to court, it doesn't matter what the standard of review is. You own the insurance company, and we, whatever we put in that record together, that set of documents is all the court's going to look at.
Okay. Can I ask this?
Ab-
The great thing about doing this pre-recorded is I'm going to edit this dumb question out. So if you're watching it and it made it through the filter, then it's not that dumb. But why? So my question is, you told me how it got there, but I mean, are that it's there? But before you got to how that it's part of the system, you gave me 4 places that you won't find it, air quote, officially.
Right. So why did the circuit court
Yeah.
create
Why?
this rule?
Why did they go that way?
Yeah. So the history of this is you got to go way back to the mid 1900s.
I know how
And,
much you hate history too, Eric.
and maybe even earlier.
Yeah.
So the essence of this is that when Congress passed the ERISA law in 1974, they mashed together rules that come from contract law, insurance law, and trust law. And under trust law, one of the general rules is that if a fiduciary, and if you don't know what a fiduciary is, think about if you're the executor of an estate, and when your mom passes away and everything is left to you and your brothers and sisters, you're the oldest kid, you're named the executor, and it's your job to decide that it's how to divide up the household fairly. That makes you a fiduciary under those rules. If you've ever heard of a trust is where people put money aside of, typically kind of rich people, they put some money aside for their kids, and the trust will say something like they can't touch this until they turn 35. Well, somebody has to be in charge of that money once the rich person passes away, and that person's called the trustee, and a trustee has to maintain that money for the beneficiary.
Right.
And so that person is called a fiduciary. And so the idea of trust law or fiduciary law got imported into ERISA, with the idea being that the employer is one of the trustees of this plan, and the insurance company making decisions is essentially a fiduciary.
Okay.
And so under fiduciary law, there's some case law that basically says there's someone rules that says what the judge is reviewing if you have to sue a fiduciary, if you have to sue the trustee or the executor, that the question is not whether they were right or wrong based on all the evidence available, but whether they were right or wrong based on the evidence in front of that fiduciary when they made the decision. So that's kind of the technical old, and that rule goes back to the 1700s in Great Britain, maybe even
Gotcha.
earlier. The
Okay.
idea that when you are measuring whether a fiduciary broke their fiduciary duties or not, you're basing it on the information the fiduciary had at the time they made their decision. So that's part of the history that the courts relied on. Another part of the history was that going back to the 1930s when the National Labor Relations Act was passed, and that's the law that has to do with unions and bargaining with unions and employee benefits that are provided for unions. They put in something called the National Labor Relations Board, and ultimately, if a bunch of union members are being denied their health insurance or being denied the benefits that they were promised, and they end up negotiating with their union and with their employer, and they go through the process of doing all that, what the courts did going all the way back to the 1930s, and this was actually set up in the law more by Congress, is that by the time you got to the National Labor Relations Board, the highest level of kind of the appeals you could go through, it was their job to just review the documents that were used by the union and by the employer to make the decision. It was a special rule that sort of had to do with whenever there's administrative law or labor relations law, that you had this closed record. And so if you got to appeal it back then in the 1930s on to court, the court definitely only looked at the information that the National Labor Relations Board had. And so when this ERISA law comes along, which is the Employee Retirement Income Security Act of 1974, courts kind of thought of it as from the family of employment law, from the
Yeah.
family of labor law. And so the instinct of the courts originally was to say, "Oh, well, we're going to do this the same way they do it under the Labor Act, like under the National Labor Relations Act." And so we're only going to review, and also kind of from trust law, we're only going to review the information that was available to the insurance company or to the administrator that made the decision at the time they made the decision.
Yeah.
So what overlapped with that was this issue of, well, what's the standard of review, and what do we mean by that? Well, the court's going to look at this decision made by the insurance company that decides your claim, and the question that the court needs to ask itself is, if we're reviewing what a trustee has done, traditionally we review that under what's called an arbitrary and capricious standard review. In other words, if you're the executor of your mom's estate and you got brothers and sisters, and your mom says you're in charge of dividing up the household goods, if one of your sisters doesn't like when you decided who got the silverware and who got the dishes and who got the family photo albums,
Mhm.
you were made the executor, which meant your mom trusted you. And for your sister to have a case in court where she's going to win, she has to show that you acted arbitrarily and capriciously. All right, that you acted unfairly.
So by
And
signing, oh, go ahead. I'm sorry.
oh, so what? So the bottom line. Let me finish this
Yeah,
thought. So
yeah.
ultimately, what I think was historically sort of a bad analogy and a bad analysis, but courts have adopted it, so now it's become a normal part of the thinking. What court said is, well, if that's the rule for a fiduciary under trust law, and these insurance companies are fiduciaries, then we're supposed to treat them with kid gloves the same way a court would treat a trustee or an executor of an estate, and give them the benefit of the doubt. So that there and I, that kind of got overturned and then moved back. So when you're ready, we'll move
Well,
on to
I
the
just
next part
wanted
of what
this
happened with that,
I
because
wanna
that's
say
a
this I wanna say this to you, and then the floor is yours. Because but so make sure I understand this, but normally, a fiduciary, uh, you have the best interest of the person you've been given charge of, that the money or whatever the
that
process
you're
is
holding
supposed to
for
be.
them
Yeah.
essentially.
So, basically what they're saying is but the insurance company has it really has their best interest at heart, and yet they are being treated like they have my best interest at heart. Am I wrong in that, or did I
Nope,
miss
that's
the
one of
boat?
the big problems with ERISA,
Yeah.
is the courts have messed that up.
Yeah.
They
Okay.
basically say, we're going to give the insurance company the benefit of the doubt as if they had your best interest at heart. And we'll talk about this. Let's hold off on this
Yeah.
until we cover the rest of the basic rules. but it only came along later were they allowed to even look at evidence that the insurance company doesn't have your best interests at heart and acted like with a conflict of interest.
Gotcha.
So
All right.
that actually comes up later on in the law, and it's a tool we use today. And I'll just skip to the important part. It doesn't mean they get to look at more evidence of your disability or the fact that you're entitled to the life insurance or health insurance. It does mean if we get the right evidence in that the court's not going to give quite as much deference to the insurance company in the right cases. But to get to that point, let's kind of finish
Yeah.
talking about the record, and then we'll talk about the standard of review. And here's how they kind of overlap and why this was important. So what happened was in several circuits around the United States, after ERISA was passed in the 1970s, as the cases started coming up in the late 70s and early 80s, they said, like I talked about a little while ago, well, this is kind of like labor law. So under labor law, the claim goes to the National Labor Relations Board. And at that point, the record closes. So we're not going to add new documents. We're going to ask the question whether the trustee was making a good decision based on the information the trustee had. So we're not going to look at anything new. And because you look at both trust law and the National Labor Relations Board to ask the question, were they arbitrary and capricious? In other words, treat them like a trustee with deference. That's how we're going to do this. Well, the Supreme Court sort of fixed some of that, but in a way that didn't really help in the long run. So here's where it gets more interesting. So in 1989, the Supreme Court decided a case called Firestone Tire versus Brutch, and Brutch was the person who was suing because he was supposed to get some pension benefits from Firestone Tire from the company Firestone, and the question went all the way to the Supreme Court. Well, what standard of review should the court apply? Should the court, under this ERISA law, be borrowing from the National Labor Relations Act and trust law and giving the benefit of the doubt to the pension plan? Or should the court also remember that what ERISA says is that because these are fiduciaries, and just flat out it says it in ERISA, they're supposed to pay benefits or at least administer their benefits uh, with the first consideration going to the employee, with the benefit of the doubt going to the employee. And so Justice O'Connor, remember, she was the justice who was appointed by Ronald Reagan back in the 80s. So she was kind of new when this decision came out. She'd been doing it for a few years. And she wrote this very long opinion that said, all right, so ERISA was a law that was supposed to make it better for employees. It was supposed to protect employees' rights to their benefits. And so we're going to go back and look and say, it's not like the National Labor Relations Act where there's a board involved. So we're not going to say that it should be arbitrary and capricious because of that. And we're not going to say because of trust law, it should be arbitrary and capricious because it's supposed to be an improvement at the way people looked at old cases that didn't fall under National Labor Relations Act, but just fell under trust law. And so what she said in Firestone Tire versus Brutch, after several pages of very thoughtful analysis, she comes out and says, this and very clearly she says that there's nothing in the ERISA law itself that says what the standard of review should be. So we're supposed to fill in the gap as the courts. We're not This is not one of those times where they just legislated from the bench. They were told by Congress to fill in the gaps. It was part of the ERISA law. And after all that analysis, she says, so the standard of review should be de novo. And what de novo means, it's the good standard of review for anybody who has a benefit issue. The court should look at the information that's submitted and make its own decision. It shouldn't rely on or analyze the decision of the insurance company or the plan administrator. That's great,
Yeah.
except, but,
Ah,
but,
I
here it
knew
goes.
it.
She said in the last like three paragraphs of the decision, but because we're borrowing from trust law, under trust law, if the parties agree to a more limited standard of review and they put that in the trust document, it could still be a limited standard of review and could be under arbitrary and capricious. And then at the very end, she said, "Oh, by the way, if the decision maker is acting with a conflict of interest, court should take that into account too." Well, that opened up. That was in 1989. That has opened up 30 plus years of all this litigation that just makes it so freaking complicated to handle these ERISA cases. You really got to know what you're doing. And the average person out there just gets run over if they don't get a good attorney, because there's the downriver effects of all that are really interesting. So the next thing that happened Do you have a question? That's a good
No,
time
I
to
was
ask.
just gonna say, my brain while you were saying that was like, I wonder if when I sign the insurance document, if I go through and just mark out the part about how it's litigated and initial it.
So that's a great question, and that I think that's a really important comment. When they say if the parties agree on a more limited standard of review, who are the parties agreeing? If you work for somebody who provides your insurance, did you get to pick out that policy?
No, it's my
Did you have any
employer.
say in what the terms were?
They presented me with the options, that's it.
Right. So let's just say at your work you have Blue Cross.
Yeah.
Who are the parties agreeing to the terms of that Blue Cross policy?
I would imagine the insurance company and the employer.
Exactly.
Yeah.
So if the insurance company and the employer are agreeing to a more limited standard review, the person who benefits from a regular standard of review, a de novo standard of review, was not part of the agreement.
No,
But the Supreme
no.
Court said, Justice O'Connor said, if the parties agree to more limited standard review. So basically, what did that mean? What do you think started happening in 1989?
Group,
Other than
they
you and I were just getting done with college.
yeah, it's just, I would imagine that the parties just started doing these big deals with companies directly
The insurance companies put that language in
in
every
the thing.
policy,
Yeah.
and every employer with a big pension plan or a big employee benefit plan added that language.
Every option had the same basic
It's
language
it
as that.
said it said the decision maker has
Yeah.
discretion, and some kind of language that says we're entitled to the arbitrary and capricious standard review. We have discretion is the key language
Yeah.
that a lot of courts look for. So it basically became the exception that swallowed the rule starting in the in 1989, and the plan started
In the late
changing.
1900s.
Yeah, but way back in the 1900s.
Yeah. All right. I
All right.
interrupted you. Sorry.
No, that's fine. This is the interesting. Anybody's listening
Yeah.
to this deep dive stuff. This is the stuff I hope they want to hear,
Yeah.
because this is the actual history of the law and how it happened. So, Supreme Court says in Firestone Tire versus Brutch, the standard review is de novo unless the parties agree, and if the parties agree, that can be more limited standard review, it can be arbitrary and capricious, but then the court can take a conflict into account. So the next year, the Sixth Circuit is a good example. I'm just going to use them of, well, what does that mean about looking at which documents are we going to look at? And so in the Sixth Circuit, the next thing they decided was a case called Perry versus Simplicity Engineering, a 1990 case. And the Sixth Circuit basically said, all right, now we're now told that the standard of review is de novo unless there's some kind of grant of discretion. And because this was a case that was already going through the pipeline, already being considered by the courts, they had the employer and the insurance company had not had a chance to add that language to the policy, so it didn't have discretion in it. So the court says we're going to review this de novo, and then the court got nerdy and down into the weeds, and I think essentially screwed anybody that lives in the Sixth Circuit. And here's what they said: there's two types of de novo under the law. One type of de novo means we start all over again and have a new trial and look at any evidence anybody has and make a brand new decision. And then they said, and the other type of de novo is we look at the records that the administrator had, that the fiduciary had, but instead of giving the benefit of the doubt to the administrator's decision, we look at it ourselves to see whether the decision was right or wrong.
Okay.
And so the Sixth Circuit, guess what they did? They said,
Yeah.
okay, of the two different types of de novo review, we were told by the Supreme Court we have to do de novo review. They didn't say we had to do de novo review with a new trial. They just
Right.
said we have to do de novo review. So we're going to pick the one that doesn't require a new trial in court. We're going to pick the one that doesn't allow somebody to submit new evidence in court. We're going to pick the one that says we're not going to look at what the administrator's decision was and give any deference to it, not give any benefit of the doubt, but we're going to say, based with having the same evidence that the administrator had, how would we decide? And
Right.
that's how the Sixth Circuit has interpreted de novo review. Now, one of the
Well, real
questions.
quick, and that's
Okay, yeah,
why though they can't let new evidence come in or new stuff in after that because they've got to put themselves in the mindset of that administrator at the time saying how they made the decision based off this material. So we've got to go back and put ourselves in that same spot. Anything new that came in, we would be penalizing the administrator because they have new information they didn't have at the time.
that's essentially the analysis. And so then
I
now
don't like
courts,
that though.
the courts are doing this one of two ways. They're basically saying, okay, if it's de novo, if there's no language in the plan, or one of the other exceptions applies, which we'll talk about in another podcast, the if one of the exceptions applies and you get de novo review, we're going to make the decision as if we were the administrator, but we're only going to look at the same information.
Yeah.
If the plan has language in it granting discretion, and the court ultimately rules under all the law that's developed over the last 30 years that the court is going to apply the arbitrary and capricious review, they not only say we're only going to look at the same evidence, but we're going to give the benefit of the doubt to the insurance company, and if the insurance company was reasonable, they win even if they were wrong.
Yeah, we've talked about
because
this on other podcasts.
because that's the benefit
Reasonable
of
but
that.
wrong makes
Yeah,
me
that's
insane.
that's the benefit of the doubt you give to a fiduciary under fiduciary law, and so the courts are applying that now. However, part of the conversation here is, remember what the Supreme Court said at the very end of Firestone Tire versus Brutch, which is, and if there's a deferential standard of review in fiduciary law, you look to see whether there's a conflict of interest, and that can affect the deference you give to the decision maker.
Hmm.
So we can, in most circuits, get new evidence in front of the judge to show the insurance company was acting under a conflict of interest and how it affected their decision. In other words, taking the depositions of the people who actually worked on the claim, getting the information about what their goals were each month. There's an insurance company that we deal with a lot that basically has something called a recovery plan, where they are telling the decision makers they have so many cases they need to recover each month, and recover is their wink, wink, nod, nod word for deny.
Yeah.
And so that's the kind of evidence we get in to show that they should get less deference or virtually no deference. But if they have the magic language in the plan, they still don't start out with deference. So one thing I want to cover before we get too far along with the standard review stuff is, you you sort of asked a good question a little while ago. You started to get it out, and I probably interrupted. Is why did the court go along with, if you got the choice of de novo new trial versus de novo just look at the same pile of evidence?
Yeah.
And this is a couple interesting things too. So I want to read something from the court, what they said in Perry versus Simplicity Engineering back in 1990. This is the Sixth Circuit, but this similar analysis is true in a lot of other circuits. They said this: a primary goal of ERISA was to provide a method for workers and beneficiaries to resolve disputes over benefits inexpensively and expeditiously. And they cited to the U.S. Code, Congressional and Administrative News. Basically, they cited to the legislative history when Congress was just debating the bill. That's what
Hmm.
that's a cite to. That workers and beneficiaries should have a method to resolve disputes inexpensively and expeditiously, and they cited to the congressional debate. And then they went on to say, permitting or requiring district courts to consider evidence from both parties that was not presented to the plan administrator would seriously impair the achievement of that goal. If district courts heard evidence not presented to plan administrators, employees and their beneficiaries would receive less protection than Congress intended.
Okay.
Here's the problem. I'm, there's a law professor from Chicago that teaches at John Marshall School of Law. His name is Mark Dubofsky. He also happens to be a practicing attorney at the same time. He's one of those people that does both. Also a friend of mine. I've heard him speak on this topic several times. He's done the research. And based on his research, that section of the congressional record, when they were debating this, they were debating a part of ERISA that never got included in the law. Congressmen were debating whether to add to ERISA a separate type of court, like an administrative court. So instead of, you file your claim with the insurance company, they say no, and now you can take it to federal court after you finish appealing it to the insurance company. They were considering creating a federal agency that would be an intermediate step, and you could appeal that agency. And that got shot down on the grounds that that would be expensive and slow down the benefit claims by having this extra government agency in there.
Okay.
So the purpose of ERISA and the law was to allow these. What Congress was saying is, we're not going to have that agency because that would add expense and slow things down. Had nothing to do with the question of whether, once you get to court, whether the record was open or not,
Right.
whether you could submit new evidence in court. The court was the Congress was not talking about that. They were talking about whether we were going to add this extra layer of appeal to a government bureaucracy. Not anything to do with what actually happens in trial if you get denied your benefits and take it to court.
And no one's kind of put their hand up and gone, excuse me. That's not what they were talking about.
Yeah,
I
several
mean,
attorneys have
you
done
I know
that.
I was
Yeah,
it was
attorneys
facetious, but
attorneys make that argument, and what do courts say? Well, we've already decided this, counselor. This is already something that's part of the rules. So one of the reasons why there's sort of this momentum that these rules didn't get changed for a long period of time is because it's easier for the court to decide these cases without having to have a trial.
that's it.
The judge doesn't want to spend 2 or 3 or 4 or 5 days listening to witnesses and having to make his own fact finding and credibility. The judge, she doesn't want to have to spend a whole week of hearing every ERISA case that comes up there. And so the way it ends up working in practicality is the evidence that the insurance company has, they put it in a big folder, or they put it in an electronic folder, and they submit it to the court, and they give a copy to us. We look at it to make sure it has everything we submitted, make sure it includes everything that they told us they had. And sometimes we can fight about that if they left stuff out or they added something they didn't tell us about. But assuming it's everything that we submitted and it's assuming everything that they created that we knew about, basically we're going to write our briefs to argue why our client should win based on the documents in that record. Maybe the judge gives us some time to go in and make oral arguments and stand in front of the judge and explain why the record is what it is, or how to interpret the record. But the court does not let us, in most cases, bring a witness in, bring a doctor in, bring any new evidence in. And so a common mistake a lot of our clients have made in the past is they don't know this rule. How would they know this rule? This is,
Yeah.
complicated stuff. Other attorneys who don't do ERISA often don't know this rule. Unfortunately, we've had times when we've had cases referred to us by other attorneys, and they think, "Well, I'm done with all the appeals. The insurance company says it's time to go to court. And oh, by the way, I just hired this great medical expert who can explain why this person's really disabled, and you can use them at trial. Would you be willing to take the case over, Eric?" And I'm like, "Did you submit that expert's report to the insurance company?" "No, I was waiting for trial." Well, you don't get a trial in ERISA cases,
Golly.
and so it people just don't know the rules. So back to how did this happen?
Yeah.
So to sum it up, the old rules that courts borrowed from, they basically said we're going to treat ERISA like we do national labor relation cases, and we're going to have a closed record and an arbitrary and capricious standard of review, just like we did in labor cases. We're not seeing anything in ERISA where the Congress told the courts they need to have trials. Now, that's kind of a little bit of difficult reasoning because the Congress didn't say you couldn't have trials either, and they didn't say the rules of civil procedure don't apply, and so arguably they should have allowed for trials, but they said we don't see anything in there that says that. And then we're going to look at this part of the statute that says these cases are supposed to be handled inexpensively and expeditiously, and we decided opening up the record and letting new evidence in would undermine that. Except that wasn't even part of what Congress was talking about. They were talking about having an extra agency that would have added expense and delay. So there's some shaky foundations for this rule. And I'll say it again, it's also important to know, if you're a lawyer listening to this, or if you're going to be litigating these cases, no Supreme Court case has said it's limited to a closed record. There's nothing in the ERISA statute says it's limited to a closed record, that no new evidence can come in. There's nothing in the federal rules of civil procedure that says that. There's nothing in the ERISA claims regulations put out by the Department of Labor. The only place these rules come from are all these cases at the circuit court level. But it's been almost universal that almost every circuit has a version of this rule. Now, you asked how does this happen, and no one's brought this up. Some people have started bringing this up, and so there are some judges recently, like in the last 4 or 5 years, especially in the last couple of years, that you've seen cases where they're starting to question it might be time to revisit these rules, because it's pretty clear this is not what Congress intended. It's not in the rules, and we just kind of made up these rules, and they don't seem to be working right. You get into arguments, and this is very technical and nerdy. Is it a rule for judgment on the record under Rule 52, where the court makes findings of fact, or is a rule for summary judgment where the court just reads the pleadings and the arguments and assumes the facts are in to the benefit of the moving party? It's very technical stuff of how you decide cases if you're not going to have a trial. And Rule 56 and Rule 52 of the Federal Rules of Civil Procedure are like the two ways you do that. And courts are struggling with this now, saying, but wait a minute, this ERISA closed record stuff doesn't fit under either one of those rules. Yes, it's a closed record, but there's still disputes of fact in terms of what do these records mean. How much credibility did we give to the disabled person's doctor who says she's got to lay down 4 hours a day and can't work because her back is
Well,
so bad, and the insurance company's doctor that says no, she can still dance ballet and play professional football?
Well, you mentioned it, and that's what I was getting to is like, how do we get some of this back on to where it sides with us, the consumer, and it's closed record at the way you described it because they've created that. I mean, it's a closed record because that's the rules. That it's a closed record. Yeah, but you made the rules. Yeah, but it's the rule. You're like, oh, that's the whole point. We're trying to figure that out. Can I ask you? I mean, this
Well,
is
so let me
again.
give you one short answer
Yeah,
there.
yeah.
The important thing is, under the rules as they have, you can still win these cases. We can still win these cases for people, but they've got to come to us before the insurance company makes a final decision. And so typically the insurance company makes a first decision and says you're denied, you have 180 days to appeal. That 180 days is crucial because if we can't get the rules changed, we can still win these cases under the current rules, but we've got to have that 180 days to work on your case and get it ready like it's a trial, to get experts involved, to talk to your doctors, to gather not just your medical records, but also reports of your restrictions, limitations, what you can and can't do. We can still win the case under the current rules as long as we get a chance to work on it early enough. Where it's really not fair is somebody who doesn't know all this gets a final denial. The insurance company says, we're not looking at anything else. And then you hire us. We can still make an argument, but we're stuck with the facts to argue over being what's already in the record. We can't change that.
Well, I'm going to give two things. Well, I'm going to say one thing, and then I'm going to ask you a question. I'm going to give a very non-lawyer, only consumer piece of advice because I've used you and your team. Here is my advice. We're going to play like Eric's not in the room right now, boys and girls. If you get a letter of denial and it says you've got 180 days, on day two, you first day you get them out. Day two, you just call Eric or an attorney and get them involved as soon as possible and not on day 178 or 187 or whatever it is. Just call. That's what I did. I picked up the phone. I was like, hey, I've got an issue. And immediately you were like, come meet with one of my team members. And I brought the letter in and I had time. And so that's just my only advice on that. And then I got a question, unless you want to say something real quick.
Yeah. So let's go ahead and cover your question because then we'll talk in a second about how there's been a little bit of a change in these rules, what some circuits are doing, but it's still important to know that it's not a great change.
Well, the only question, and it's just your opinion, but I mean, you said something a minute ago that the judge may not want to look at this and have a new trial because it's 3 or 4 days. It's much more expensive. It may delay the benefits. All this. Is there some truth to that because of the number and the tonnage of denials that they're getting? Is it an issue of the courts will get clogged up because of it? I mean, is that a legitimate logistics thing, or is that kind of a default excuse? That's what you're there for. That's part of the process.
So I think there's two sides to that sword. One is that if all these claims really did go to trial, it would add additional trials to the court system. However, I'll say this: 97% of cases that are filed in federal court that are not criminal cases but civil cases, I think it's something like 97%. Don't quote me. That's a number, but it's about that. It's somewhere around there. 97% of cases you file in civil court settle. And what gets people to settle is when all the facts get on the table, both sides can see what you're working with,
Mhm.
and it's more difficult work to continue to get all the evidence together to prepare a case for trial. And a lot of cases settle right before trial. So the
Mhm.
insurance company, knowing that they don't have a trial, all they have to do is pay an attorney to write some briefs, unfortunately, is less likely to settle the cases as they are now. And
Gotcha.
I would submit that in cases where we can get a trial, which are the ones that don't fall under ERISA, that they're much more likely to settle at some point. The insurance company's willing to put up enough money often to settle those cases, in part because they know the trial is going to give our client a fair chance, and in part because it's all the extra work of doing it right. Now, the other side of that coin is that if these cases don't settle, yeah, it's going to take longer for these cases to litigate. I just think that they'll force people to settle, force insurance companies to settle more, or at least offer reasonable money more often. And the other part of it is that if we did have trials in every case, sometimes the insurance company could show, because they have giant piles of money like Scrooge McDuck's basement, and they just spend all this money hiring their own experts that they'll bring to trial. So
Yeah.
then it gets to be a little bit more difficult question. Are we going to have your doctor and have to pay your doctor to sit for a deposition and pay your doctor to come testify and maybe pay two of your doctors to come testify, maybe pay for a vocational expert? And so it can get a little more expensive if your case is going to go to trial. But I think the counterbalance to that is those cases are more likely to settle as well.
Okay.
Now, so let me clarify one thing, or at least talk about a little bit of the update. So we talked about this earlier in this podcast. The Seventh Circuit, which is Wisconsin, Indiana, and Illinois, they've had a long history of their circuit court being very interested in this stuff, and they've got a judge named Posner who's like kind of famous in the judicial circles as one of those people who should have been on the Supreme Court and just it didn't never work out. But he's a really smart guy. He's been up there for a long time. I think he's recently retired. But part of the history there was the Seventh Circuit has basically kind of gone back to the rule where we were talking about what does de novo mean, and they say, well, if it's arbitrary and capricious, you get a closed record, but if it's de novo, you can get an evidentiary hearing, and maybe your doctor can come in and testify.
Okay.
Now, the good news is if your record is not very good, if you appealed on your own and your doctor didn't give a good statement, well, maybe we can get that into the case if you live in those states. Maybe we can get that in front of the judge. The bad news is that means the insurance company can do the same thing. They can use all the piles of gold they have down in Scrooge McDuck's basement and spend all the money in the world to hire experts.
Yeah, let me just go ahead and clear that up for young folks. That's twice he's referenced an old cartoon that we grew up with, Scrooge McDuck. But that's all the gold in the
It
basement.
was
Yeah,
Donald Duck's uncle, and
uncle.
there's
Yeah,
famous scenes when we were kids in the old cartoons, the old comic books, of him literally swimming
I mean in
in
money.
his gold coins. I think
Yeah.
the reference that our younger friends who don't know Scrooge McDuck is, picture the scenes from The Hobbit when they first see the dragon inside the mountain and the piles of gold that the dragon was sitting on.
Hmm.
That's like a little portion of Scrooge McDuck's basement
Yeah. Okay.
without a dragon.
Thank you for updating us without the dragon. I appreciate it. That's good. See, look, we can make insurance and law fun. We're talking about dragons and cartoons, and it's good stuff. What else do we have, man? What else do you want to go over and make sure, other than making sure people know how to get in touch with you? We can do that at the end. What else do we need to talk about on this deep dive around this topic?
So let me just clarify a couple things or just
Yeah.
reinforce a couple things. If you get a letter from an insurance company saying they're going to deny your benefits, long-term disability, health insurance, life insurance, and you have X number of days to appeal, you have a certain number of days to appeal. For disabilities, typically 180. For other types of claims, it can be as short as 60. The time to call us is at the beginning of that time period. If we can help you, we want to get involved as early as possible to make sure the record is as good as possible. If there's a way around the closed record rule, that's part of what we want to know. If there's a way we can affect the standard of review, there's been some changes in the ERISA regulations for cases filed since 2018 that make those rules a little bit better. We'll talk about that on another podcast. But there are some ways that you might get out from under arbitrary and capricious and get a de novo review if you know how to work the system and do the appeals properly and make the other side follow the rules. So that's important to know. But the best thing the way I can make the analysis for people is that time period to do the appeal is basically our chance to prove your case. It's our chance to put on the evidence like it's a trial. We want to put it on and give it to the insurance company so your case looks great when it gets in front of the judge. We don't want to have to get the judge to only look at stuff that the insurance company put together to make their case look great when it was somebody who didn't have an attorney and didn't do a very good job of putting that evidence in the record. So later on, we'll talk about more about the standard of review and how you can get evidence in showing the insurance company if they're acting under a conflict of interest. That's something the court should take into account, and that's something we work on for everybody as well.
Well, and I'll say it one more time from a consumer standpoint. The insurance company has attorneys. I want someone that knows how to speak attorney. I want someone knows that how to play that game. I want someone to know that can represent me that's playing for my team. And that's why I believe in calling, an attorney like Eric and his team is because I don't speak attorney. And so, I'm a big believer in doing that as soon as possible. Anything else you want to add? You want to tell people how to find you? If not, I can. It's up to you.
Yep. So if you're on our website, thank you. You're there at buchanandisability.com. If you find this somewhere else in the World Wide Web, It's buchanandisability.com. We're located in Chattanooga, Tennessee. We have right now 6 attorneys, including me. We work as a team. We have lots of good paralegals and staff. We handle ERISA, long-term disability, and disability insurance, health insurance, life insurance cases all over the United States. We work directly in states where we're licensed or where we can get admitted, and where we can't, we have local attorneys that we work with, or we can find some in those jurisdictions we haven't been before. But for the most part, we already have working relationships that cover a large part of the United States, and we're happy to talk to you about these cases no matter where you live.
Eric, thanks for letting me be part of this, man. I appreciate it.
Yeah, great job, Clint. Thank you very
All
much.
right. Talk to you, everybody. Y'all have a good day. Bye. We're out, dude.